Good afternoon, and thank you for joining us today for the second webinar in Stern, Kessler, Goldstein, and Fox's PTab 5th Anniversary Series, 5 Years at the PTab, Lessons Learned. Allow me to introduce our speakers. Dr. Eldora Ellison is a director in the Biotech, Chemical, and Litigation Practice Group. She also co-chairs the firm's Patent Office litigation practice. Over the course of her 23-year career, Dr. Ellison has gained extensive experience in inter partes patent matters, building on a strong foundation in patent prosecution. Dr. Ellison's experience includes representing clients in over 60 inter partes review proceedings, more than 15 patent interferences, and in various patent reexaminations and district court litigations. Dr. Ellison represents a variety of types of clients, including large multinational corporations, startup companies, and not-for-profit organizations. She has been recognized by numerous legal publications as a leading practitioner in the life sciences, and she has served as an expert witness on patent matters. Most recently, Dr. Ellison was named PostGrant Proceedings Attorney of the Year by LMG Life Sciences. Rich Kohler is a director in the Mechanical Group. Rich specializes in obtaining patent protection for cutting-edge technologies in the medical device and consumer product areas and conducting complex AIA trial proceedings at the PTab. Earlier this year, the Legal 500 recognized Rich as a next-generation lawyer, noting that he is highly recommended for patent prosecution and AIA trial proceedings by clients and peers. Rich is also serving as a member of the Intellectual Property Owners Association's U.S. Post-Grant Patent Office Practice Committee for the 2016-2017 term. And with that, I will turn it over to our speakers.
As we've dealt with the America Invents Act and the PTab in the last 5 years. We've laid out on slide 2 a rough agenda of the various topics that we plan to address today, including the scale and scope of the proceedings. We'll mention some of the significant cases. We'll talk about the impact of multiple parties and multiple petitions that we've seen in various cases, and also the impact of IPRs and other proceedings on concurrent litigation, as so many of these cases are involved in concurrent litigation. Finally, we'll also talk about motions to amend, which is an area that has definitely changed quite a bit over the course of the last 5 years, including most recently with the decision that came out just a few days ago. We'll also talk about estoppels. That's definitely an area that was of concern to people when we entered into this venture 5 years ago with IPRs, and that has evolved over time as well. And then finally, we'll address some standing issues, some of which I think are quite interesting, and appeals and remands. So with that, let's talk first about the scope of these proceedings. The Patent Trial and Appeal Board has become the largest venue for patent disputes, as we like to say, the largest venue in the country, the largest venue probably in the world, and that's also probably the largest venue in the galaxy, as my partner Jorge Goldstein would often say. Looking at some of the statistics on slide 4, we now have seen over 6,700 IPRs and more than 7,000 post-grant proceedings in total. A healthy number of covered business method reviews, 524 of them as of the end of July. Still only a handful, relatively speaking, of post-grant reviews. Undoubtedly, that's partly because these proceedings are only available in the first 9 months on patents having an effective date after March 16, 2013. But I think we'll continue to see these, particularly in the life sciences, because of the ability to challenge patents under any validity grounds that exist. And not mentioned on this slide, these slides, of course, come from the Patent Office. Not mentioned on this slide are derivation proceedings, which also were ushered in with the AIA, and there's really only been a handful of those and no final decisions yet, to my knowledge. Looking at slide 5, we see that these kinds of proceedings have been available and used across a variety of technical areas. And one thing that was perhaps surprising to practitioners is the percentage of them that have been used in the bio and pharma industries. 11% of the proceedings have been used in that technical space, And that's in marked contrast to the pre-existing inter partes reexamination proceedings that were much more heavily used by just the electronics and mechanical industries. But the life sciences have taken a liking to these proceedings, to the surprise of many, and I think I've heard even the Patent Office acknowledge their surprise at this. And everyone, I think, including the Patent Office, has been surprised by the overall number of proceedings, the over 7,000 that I mentioned to you previously. It's been far more than expected, yet somehow the office has managed to deal with it. So looking now at slide 6, when IPRs first came along, people became attracted to them once they saw the institution rates and once they began to see the effectiveness of these proceedings in terms of bringing parties to the table and bringing issues of patentability and validity into the light. The high institution rates that we saw at the beginning of these proceedings has declined somewhat, but it's still really quite significant, leveling off in the 60-something percentage, 63% so far for fiscal year 17. And then likewise, also of interest has been the relatively high rate of claim cancellation. Now, when you get into these statistics, there are a lot of debates about what numbers should count or not count, but I like to look at the last sort of bar on this chart, which is when you get to a final written decision and the board has to make a decision as to whether the claims are patentable or not unpatentable, how does that shake out? Across the board, they have found that 65% of the claims have been deemed unpatentable. In 65% of cases, all of the claims have been found unpatentable. In 16% of the cases, some of the claims have been found unpatentable, and in just 19% of the cases, no claims are found unpatentable. These numbers are a little different, again, when you get into life sciences. I think the claim cancellation rate's around 55% or so, so it's lower than in some of the other arts. But it's still pretty remarkable compared with district court. And for this reason alone, I think these proceedings will continue to be popular amongst parties, provided they're held constitutional. And with that, I'll turn it over to Rich.
Thank you, Eldora. So both the Supreme Court and the Fed Circuit have issued a number of significant judicial decisions that impact practice before the PTab in these AIA trials. And while an exhaustive review of the most important decisions is really not feasible in this brief webinar today, we've decided to highlight two up front, one of which Eldora alluded to, in addition to some others that will be sprinkled through the remainder of the presentation. But turning to slide 9, let's start with the Cuozzo decisions, which I'm sure most of our listeners are familiar with. They're really seminal decisions in the IPR area, and they were also the very first Federal Circuit and Supreme Court AIA trial decisions to issue. So many practitioners originally expected that claims reviewed in AIA trials would be considered under the broadest reasonable interpretation, or BRI standard, not the P.L.L.C standard used in district court, kind of sticking with the Patent Office's historical practice in both ex parte prosecution and even in reexaminations. So in the Federal Circuit's Cuozzo decision, which stemmed from an IPR appeal, the Fed Circuit upheld the PTab's use of BRI, which they implemented by rulemaking. On appeal to the Supreme Court, the court unanimously affirmed the Fed Circuit and endorsed the PTab's use of BRI at AIA trials. Now, of course, this standard tends to favor petitioners, so a lot of patent owners were upset about that. A lot of people raised various challenges, but Cuozzo, at least today, is the definitive decision on that front. So another issue in Cuozzo, again, there really were two major issues that came out of the Cuozzo line of decisions. The other one was whether judicial review is available from PTab institution decisions. So the relevant statute, of course, is 35 U.S.C. 314D, which is titled No Appeal. States that the determination by the director whether to institute an inter partes review under this section shall be final and non-appealable. Now, the Federal Circuit interpreted that appeal bar language to effectively preclude any judicial review of most decisions regarding institution of an AIA trial. On appeal on this particular issue, unlike the BRI issue, there was a little bit of a split. The Fed Circuit held by a 7-2 margin that 314D precludes judicial review of institution decisions with respect to the sufficiency of pleadings for a proposed ground of unpatentability. Now, Justices Alito and Sotomayor dissented from that portion of the holding, and in many people's view, those dissents have left some room for arguments that appeals of issues not tied to the sufficiency of proposed grounds of unpatentability may actually still be permissible. There are a number of examples, and a number of people have brought challenges post-Cuozzo. One example would be the 315B time bar for potential petitioners, which indicates that a petition can't be filed against a patent more than 1 year after the challenger is served with a complaint alleging infringement of that patent. And this is exactly the issue in the Wi-Fi 1 case, which is currently awaiting a decision from the Fed Circuit after an oral argument from an en banc review this summer. So the issue there is whether the PTab's application of the 1-year bar in instituting trial is appealable. So there are a lot of cases that are similarly postured that are all kind of awaiting the outcome of Wi-Fi 1, and that could be one example of many that are exceptions to the general Cuozzo rule of non-appealability from institution decisions. So what are some of the key takeaways from Cuozzo? The first one, it's pretty straightforward, but bears repeating. It's that BRI is likely here to stay in PTab trials, of course, absent a statutory change by Congress, of which there have been some proposals that would tweak this and align the claim construction standards with the district court standard. The other takeaway, I think, from the appealability angle is that in addition, that the PTab is being given really great deference. Some might even go so far as to say unchecked power in deciding whether to institute trial. So kind of fast forwarding from Cuozzo, one of the first decisions, to oil states, which is more timely and kind of a hot topic right now. This was the case that Eldora had alluded to. Oil states really started off as a fairly mundane case procedurally. So a patent owner appealed an adverse written decision from the PTab to the Fed Circuit that raised a number of issues. The last one of 4 was the constitutionality of AIA trials as a whole. And so this, I say procedurally unacceptable or mundane, unexceptionable or mundane, because this was not the first time that there was a challenge to the constitutionality of the AIA trial regime. In fact, the Fed Circuit has repeatedly turned away constitutional challenges to IPRs and other post-grant proceedings. And likewise, the Supreme Court has denied several cert petitions on the issue. So the most recent example prior to oil states was the MCM portfolio case, where, again, very similar, substantially similar issues. The Fed Circuit rejected them. They did not grant en banc review, and the Supreme Court denied cert. So, again, turning to oil states specifically, oil states lost its appeal, and in fact, the board's decision, the Fed Circuit's decision in oil states was a Rule 36 summary affirmance. No explanation, no decision, and a request for rehearing at the Fed Circuit was denied. But nevertheless, the Supreme Court, to the surprise of many in the patent bar, did grant cert. And so the issue presented, to condense it a little bit, is whether IPRs violate the Constitution by extinguishing private property rights through a non-Article III forum without a jury. So as an indication of how much interest there is in this case, there were 32 amicus briefs filed. Oral argument is scheduled for later in November, November 27th. I'm sure it will be closely followed by many. And I certainly don't present myself as a constitutional scholar. I've not read all the briefings, which if you do take a look at them, delve into the 7th Amendment, 19th century Supreme Court law, and even further back going into English common law. But what I do know is just one person's opinion or perspective here, a decision wiping out IPRs, post-grant proceedings in general, which I think if it went that way would have to also wipe out reexaminations. I mean, it goes without saying it would be massively, massively disruptive to the system. I don't know that the court is going to go there. If not, why did they grant cert? Perhaps it's because this issue has come up again and again, and they kind of want to put a stop to it. It really will be interesting to see what happens. Personally, I think they will uphold the IPR regime. Maybe we'll get some dicta in the decision that talks about other ways that the system could be tweaked or improved without scrapping the whole thing. But certainly a case to watch closely.
Another case that has worked its way up to the Supreme Court and that they'll look at this term is the SAS Institute versus Lee case, which is a case in which the court will consider whether the PTab is required to issue a final written decision as to every claim that a petitioner challenges. Or does the court only have to issue the board only have to issue a final written decision with respect to the claims on which the board instituted trial? So now that we're 5 years in, we've already had several cases that have worked their way up to the Supreme Court, and I think we'll be standing room only for these hearings, as Rich implied. So one thing that we've seen arise, and again, perhaps more than people expected 5 years ago, is that key patents are being challenged over and over again in IPRs and other proceedings at the PTab. Just as an example, by my count, the patents that relate to the drug Humira, which you all see commercials for all the time, those patents have had, by my count, 17 IPRs filed against them, including 6 IPRs by the same petitioner on the same patent. So I think the message to patent owners is if you have a patent that's, I'll call it a key patent, so potentially a blocking patent, especially if it relates to a blockbuster product, you can most likely expect that there will be multiple IPRs by multiple challengers and including multiple IPRs by the same challenger very often. And I think this is particularly true in the life sciences and in the biologics space where people are trying to bring biosimilars onto the market. So now that we've been seeing this for a number of years, I think the PTab has grown a little weary of it, frankly. And in a very recent decision that came out less than a month ago, the General Plastic versus Canon IPR decision, the board addressed this issue of multiple IPR challenges against the same patent, particularly by the same petitioner, and they chose in this instance, as they've done in other cases, to exercise their discretion to deny trial. And this case is one in which the board issued a decision that it labeled informative, which the board does not very frequently do, but they did it here on this decision from an expanded panel. So what happened here is that the petitioner filed a first set of IPRs, and the board denied trial on those, and the petitioner then filed some follow-on IPRs, and the board chose to exercise its discretion under 35 U.S.C. section 314A to deny trial. And they laid out some factors that they considered in denying trial. These same basic factors were previously laid out in a decision involving NVIDIA. And here the board looked at whether there was a previous petition on the same patent, and whether the petitioner knew or should have known of the prior art that they relied upon in the later petitions, whether the petitioner had already received the patent owner's preliminary response from the first patent challenge or decision on institution from the earlier patent challenge. And that's, of course, a negative factor. You know, if you use those prior briefing, the POPR, or the decision on institution to sort of retool your challenge in the later petitions, the board looked upon that disfavorably. They also considered the timing between when the petitioner learned of the art that they relied upon in the follow-on petitions versus the filing of the follow-on petitions. And they looked for any explanation for this delay or timing between petitions that were directed to the same claim. And of course, as you can imagine from the over 7,000 IPRs and other proceedings that have been filed to date, the board has finite resources. And so the board takes that into consideration in deciding whether or not to institute trial, along with the fact that they need to issue a final written decision within 1 year of institution. And so in considering all of these factors, in cases like the general plastic case, the board said, no, we're going to exercise our discretion and deny trial on these follow-on IPR petitions. So I think from the petitioner side, if you're devising a strategy, a multi-pronged strategy for trying to nullify a patent that you don't like, you really need to bear these factors in mind because the board may not take too kindly to your litigation tactics, depending on what they are and depending on what the circumstances, of course. And of course, on the flip side, as a patent owner, if you feel like you're being harassed by a petitioner, you know, consider these factors and consider whether you may get some traction with the board in complaining about the multiple petitions. Another instance in which the board and then the Federal Circuit have recently looked at scenarios involving multiple petitions relates to the topic of joinder. So as many of you may know, if one party files an IPR petition and another party that is statutorily time-barred from filing a petition because they waited for more than a year from being served with a complaint alleging patent infringement, if they're statutorily time-barred, that time-barred party can file its own petition and move to have that petition be joined with a first IPR petition that's not stat-barred, because that time-bar doesn't apply in the case of joinder. So we see many instances where a second petitioner will come along either because they're stat-barred on their own, or even if they're not stat-barred, and they may move to join a first IPR petition. And again, we see that a lot in these life sciences cases that I mentioned. Sometimes that second petitioner just wants basically a seat at the settlement table, and they want to get involved in the proceeding without doing all the heavy lifting. And so they may seek joinder and just agree to have a kind of backseat in the proceeding. But in this NIDEC motor case that's mentioned on slide 13, NIDEC filed a first petition, and then after the 1-year time bar, NIDEC filed a second petition that raised new issues, right? And it's against the same patents and same claims. And so NIDEC's second petition would be time barred except for this provision of the statute that waives time bar in the case of joinder. The PTO allowed this. The PTab thought it was fine for that second time barred, otherwise time barred petition to be joined in. But whether that's proper or not under Section 315C is the topic of debate. Can this same party join in a time-barred second petition, and can they just bring new issues in with that second petition? This case went up on appeal to the Fed Circuit. The Federal Circuit did not actually end up having to decide this issue because they affirmed the PTab based on the original, the issues raised in the original petition. But two of the judges, Judges Dyke and Wallach, in their concurrence expressed some concern with what transpired here. And so they asked, or they stated, the issue is whether the time bar provision allows a time bar petitioner to add new issues rather than simply belatedly joining a proceeding. And these two judges from the Fed Circuit thought that the statute does not explicitly allow this practice. And so this issue has been raised in other cases, and I'm sure it will arise again. And at some point, we'll actually get some final clarity from the board as to whether this is proper or not. But we can see there's at least some concern from some judges at the Fed Circuit on this issue. The other issue that the Fed Circuit expressed concern with was over the PTab's use of expanded panels. The original panel of judges at the PTab was, of course, a 3-judge panel. When the patent owner requested rehearing, the board used an expanded panel of 5 judges, and I guess some people question whether those additional judges were selected to achieve a certain outcome or not.
Great, thanks, Eldora. And so we'll switch gears now to talk about stays of concurrent litigation. in view of IPRs and other post-grant proceedings. So with reference now to slide 15, I think it's fair to say that the strategic role that post-grant proceedings play in district court litigation has differed from what many stakeholders would have expected when the when the AIA was initially enacted. AIA trials have been billed as low-cost alternatives to district court litigation. That was kind of the talking point coming out of the PTO and Congress. But in practice, as those of us who practice in this area know, post-grant proceedings are frequently pursued in parallel with underlying enforcement actions. And typically it's the filing of an infringement complaint that is the trigger for filing an IPR or other proceeding. Only CBM provisions of the AIA actually provide for high likelihood stays. In the IPRs, PGRs do not have similar language there, kind of strongly encouraging a stay. And if you look at the statistics, they really vary a lot by jurisdiction. I pulled up just a few examples here based on the most recent data I could find, and it looked like in Northern District of California, about half, and these stats are just for IPRs, about half of contested motions to stay are granted. In Delaware, it drops down to about a third, and in the Eastern District of Texas, it drops down to about a quarter. So you can see, again, even just within these three jurisdictions, a fair amount of variation, but certainly stays are not being granted at such a rate that the IPRs are predominantly serving as the vehicle for moving forward in the dispute, while the district court case is on hold. It's the opposite. So again, the parties will find themselves often kind of fighting the district court front and the IPR front at the same time. It can be complicated. You have different evidentiary burdens, different claim construction standards, as we mentioned, with respect to Cuozzo, so it can be complicated if the district court case is not stayed. So if we turn to slide 16 then, what we've got up at the top here, and I won't read through all of these in the interest of time, but there are the traditional factors that district courts would look at when deciding whether or not to stay a case. And those three factors are listed up top under the first bullet. For CBMs specifically, the AIA by statute added a fourth factor. It was that the court must consider whether a stay or the denial thereof will reduce the burden of litigation on the parties and on the court. And if you look back in the legislative history, congressional debates, when this was being enacted, Senator Schumer, who was one of the senators who spearheaded the CBM language, stated on several occasions that he considered the addition of this fourth factor, or the four factors as a whole, as placing a heavy thumb on the scale in favor of a stay. So at least with respect to CBMs, there was a much greater expectation of a stay, but again, that language by statute does not apply to IPRs or PGRs. So kind of more practically speaking, what's driving the outcomes here, if you look at the second bullet and subpoints on slide 16, what are courts looking at? Has trial been instituted? If you're coming in and asking for a stay after the petition's filed, but before an institution decision has been entered, you're in really any jurisdiction, you're highly unlikely to get a stay. Waiting till after a favorable institution decision would be the way to go there. Another factor, some courts are saying, did the petitioner delay in filing their IPR petition after being sued? Of course, you have 1 year because of the 1 year bar. Some courts seem to care. Did you wait until right up to the 1 year bar, or did you get things moving earlier? The third one, I think, is one of the more important points. Is there complete or substantial overlap in the claims? I've seen many cases where if all of the claims at issue in the district court litigation have been found likely unpatentable in an IPR institution decision, that kind of makes it an easier decision for the court to say, yeah, I'm going to stay this because we have overlap in the claims that are challenged. Whereas on the other hand, if you don't have overlap, which sometimes a patent owner can achieve by amending their complaint later after the IPR petition is filed to add new claims into the mix, if you no longer have, overlap or unity there, the district court judge can, reasonably say, well, even if the IPR moves forward and all the claims are invalidated, we're not going to have, that won't resolve all the issues. So that's something to look out for, all things being equal. Maybe it's not a bad idea as a petitioner to the extent that only a subset of claims in a patent are asserted in district court, maybe you IPR everything in your petition, or at least everything that reasonably could be asserted against you in district court. Similarly, the last point, is there overlap in legal issues? Cases at the district court where there are significant 101 or 112 issues that would not be addressed in, say, an IPR, the IPR is not going to resolve everything. So those are kind of some of the fact-specific things that the courts are looking at.
So when IPRs first came along, some stakeholders had some hesitancy or reluctance to use them because of the possibility that the patent owner could move to amend their claims. And that was particularly of concern to some stakeholders for patents that were involved in litigation. But the statutory provision allowing for motions to amend claims have not thus far resulted in many actual amended claims arising out of IPRs. A couple of years ago, the Patent Office, not a couple of years ago, last year, the Patent Office conducted a study on motions to amend, and they did this in response to fairly widespread complaints about perceived difficulties in the ability to amend claims in an IPR. And so, although these numbers are from last year that you see on slide 18, they actually remain still pretty accurate. The long and short of what this somewhat complicated slide shows is that in only about 8% of cases at that point in time had the patent owner even sought to move to amend its claims. And I think over time the number has gone down just because stakeholders, patent owners, became so pessimistic about their ability to succeed in amending their claims in an IPR. So out of about 118 cases in which a motion to amend was actually decided upon, that's that blue slice on the slide, and only out of those 118 cases, and only 6 of them did the board grant the motion to amend either in whole or in part. And the vast majority of the motions to amend were denied for various reasons, as shown on the left-hand side of the slide. Many of them were on the merits because the amended claims still presumably were anticipated or rendered obvious over the art of record. In many instances, it was for some statutory reason. In some cases, it's because the claims as amended were found to lack written description or be directed to non-statutory subject matter. But the key here is that one of the reasons that stakeholders have complained over the years about the ability to amend claims in an IPR is because the office had placed the burden on the patent owner to show that the amended claims are patentable over the art. And there's a series of cases that I don't have listed on the slides, but it includes cases like Idle Free and Microsoft v. Proxicon and Master Image, where the board had concluded that the patent owner bore the burden. Well, that's changed now, at least to some degree. So in a recent case, a case just very recently decided on October 4th from the Federal Circuit, the Federal Circuit addressed the issue of who carries the burden, and this is the Aqua Products versus Metal case. This is a case that arose out of an IPR. There was an appeal. There was an en banc decision or en banc hearing in the appeal. The en banc hearing was last December, December 9th of 2016, yet the Fed Circuit took until October 4th to issue its decision. And if you read the decision, you can see why it took so long, because it ends up being 148 pages with concurrences and various opinions from practically every single judge. But there were two main issues that the Fed Circuit looked at there. And one of them, of course, was on this issue of burdens and whether the Patent Office can require the patent owner to bear the burden regarding the patentability of its amended claim. And then let's say the petitioner drops out, maybe the parties settle. Can the Patent Office still place that burden on the patent owner to show patentability of the amended claims. As I mentioned, the decision here and the opinions, the various opinions, are very lengthy and complicated, and so it's a little difficult to wade through them or to reach conclusions from it. But there's certainly one key conclusion that you can reach that all the judges agreed upon, which is that in looking at the statute as it currently stands and in considering any deference that may or may not be owed to the Patent Office's interpretations of its own rules, the Fed Circuit concluded that Congress explicitly placed the burden of persuasion to prove propositions of unpatentability on the petitioner, and they did this for all claims, including the amended claims. And so the patent owner no longer carries the burden affirmatively in these motions to amend to show patentability of their claims, but that burden remains on the petitioner. And there's numerous discussions of various cases where the Fed Circuit points out that the burden to show unpatentability stays with the petitioner and never shifts to the patent owner. And so in one of the footnotes, the Fed Circuit explained that to the extent that their prior decisions, like the cases I mentioned, to the extent that they're inconsistent with this conclusion about who carries the burden, they overrule those decisions. And then if the challenger drops out because, let's say, they settled and the board proceeds to a final judgment, the Fed Circuit concluded that it's the board that must justify any findings of unpatentability. And they have to do this by reference to the evidence of record in the IPR. And certainly in the past, patent owners have expressed frustration of feeling the need to show patentability over essentially all the art in the world or all the art known to them. So this case, I think, will give some additional comfort to patent owners. Its confines and contours are still to be refined and debated and discussed. And it remains to be seen what the office will do now that it has received its decision from the Fed Circuit. I know of at least one pending case where the board has looked to the parties and asked the question of whether additional briefing is appropriate in that ongoing case. And to my knowledge, of course, the board has not yet issued any kind of guidance or anything relating to aqua products. But it'll be very interesting to see whether this decision has an impact on patent owners' actual abilities to amend claims in IPRs.
So shifting gears now to talk about estoppels, and more broadly, today one of our goals was to kind of flag issues that are rapidly evolving or that kind of initial expectations that implementation of the AIA were kind of overturned on their head, and I think that's probably the case for estoppels. So, I think a lot of patent owners were surprised about some of the decisions that have come down that are kind of reining in or limiting the scope of what people thought the estoppels might look like. It's really a series of decisions from the Federal Circuit that seems to have limited the reach of estoppels. Petitioners have argued that, to the point where petitioners are arguing that grounds that were not instituted and adjudicated before the PTab are still fair game in district court. So the statute governing IPR estoppel prevents a petitioner or real party in interest from asserting invalidity in a subsequent proceeding on any ground that the petitioner raised or reasonably could have raised in IPR. That's 315E generally. Subsection 315E1 prevents a subsequent validity challenge before the PTab, whereas 315E2 deals with a subsequent challenge at the ITC or in district court. Now, if you look at what the district courts of the PTab are doing, I would argue that there's actually kind of a division or a split between how district courts and the PTab are treating these estoppel provisions. So the first place to go to on this issue is really the Federal Circuit's Shaw decision. So in Shaw, the Federal Circuit held that estoppel does not apply to grounds that were denied institution by the PTab in an IPR because this is a quote, the IPR does not begin until it is instituted. maybe somewhat of a philosophical or statutory parsing interpretation. But in any event, in Shaw, one ground was deemed by the board panel, as they often do, one ground was deemed redundant by the board, and therefore they did not institute only for that reason of redundancy in the IPR. So as a result of Shaw, district courts after Shaw are generally holding that, generally have held that grounds that are asserted but that are denied institution in an IPR can be raised in a later litigation. So there was a subsequent case to Shaw in the Northern District of California. This one's not on the slide. The case is IV v. Toshiba. And Toshiba challenged the validity of IV's patent in district court, claiming that IV's patent was obvious in light of two patents that Toshiba had never even asserted in its previous IPR petition. So this is not like Shaw, where they had grounds that were not instituted as redundant. These were pieces of art that they did not raise at all in the IPR. So this court in the IV case observed that interpreting Shaw to allow Toshiba to assert references that were never presented to the PTab at all, despite them being public, would confound the very purpose of IPRs. Nevertheless, that IV court could not divine a reasoned way around the Fed Circuit's interpretation of Shaw. So in that case, the district court refused to apply Estoppel. So turning to the next slide, slide 24, the direction of Shaw and how broadly it should be interpreted is kind of coming to a head and being flagged by a lot of district court judges. In this case, the Piscotty case on slide 24, it was, I believe, a magistrate judge who observed that a broad reading of Shaw and another related case, HP, has prompted increasing concern in the trial courts. So in that case, the magistrate went on to recommend to the judge that he adopt a narrow view of Shaw to exempt an IPR petitioner from 315E's Estoppel provisions only if the PTab precludes the petitioner from raising a ground during the IPR proceeding for purely procedural reasons, such as redundancy. So again, that interpretation of Shaw would kind of box it in to its very narrow, specific facts related to redundancy, but not more broadly prevent estoppels from applying. So turning to slide 25, again, earlier I mentioned there's something of a split in how the PTab and the district courts are interpreting Shaw and applying estoppels. So there are a couple of different cases here, Praxair and Great West. I don't think we need to go into both of them in excruciating detail, but there's another case not on the slide, APX v. Wyeth, an IPR, where the board denied an obviousness ground because the prior art had been cited, though not put forth as prior art in an earlier IPR petition. And in that case, the board held that the obviousness ground was a ground the petitioner could have raised, and therefore the petitioner was stopped from doing so under 315E. If you look at the language from Praxair and Great West, there's some pretty strong language from the board refusing to apply Shaw broadly and applying the hypothetical skilled prior art searcher standard for determining whether prior art could have been found out there. So again, this is a very different approach than most district courts are taking and that a broad interpretation of Shaw would dictate. So it will be interesting to see when all of these district court and IPR cases go up on appeal to the Fed Circuit if the holdings of Shaw stand up or if the Fed Circuit kind of switches gears.
You know, when we talk about estoppel, I always like to remind people that there's also patent owner estoppel, which of course means that if you're a patent owner and you receive an adverse judgment as to a claim in a post-grant proceeding, then you will be stopped at the patent office from pursuing claims to the same or substantially the same subject matter. And it's actually a very difficult issue to research. There's not a good way to find how the office is applying patent owner estoppel. So I had one of our summer associates spend a lot of time digging into this issue, and we published a paper on it in Law 360 a few weeks ago. But there are instances where the patent office is indeed applying patent owner estoppel against patent owners who have had their claims receive an adverse judgment in a post-grant proceeding. And we saw it particularly in the instance of re-exams or reissues, but even in just related child pending applications. And so you've heard many of us and our colleagues recommend considering track 1 applications if you are involved in or see yourself potentially becoming involved in a post-grant proceeding, to get that track 1 patent issued quickly. And the existence of patent owner Estoppel, I think, just kind of underscores why you may want to get some more patents issued quickly while you can. Another issue that has received considerable attention, especially very recently, that I think most of us did not predict 5 years ago in the context of IPRs, is one of standing. And I'll address this in a couple of different scenarios. So one relates to sovereign immunity and whether 11th Amendment immunity, for instance, can immunize a patent owner from having their patent be challenged at the PTab. I don't recall this being discussed at all during the many legislative debates as the AINA was heading towards enactment, but it's certainly getting the attention of Congress now, particularly for reasons that I'll get to in a second. But earlier this year, we saw the Covidian versus University of Florida Research Foundation case, where Florida said, hey, we're an arm of the state, we're an entity of the state of Florida, and we should be afforded immunity under the 11th Amendment, and this IPR should be terminated. And the PTab went along with that argument and terminated that IPR. And subsequent to that, we saw the University of Maryland also make such an argument and succeed in getting termination. And then, interestingly, there's also the reactive surfaces versus Toyota case, which also involved the University of Minnesota. And Minnesota had trial against it terminated, but Toyota was not able to rely upon that to have the proceeding against it terminated. And then more recently, many of you have probably seen controversy in the press relating to IPRs that Mylan, Teva, and Acorn filed against Allergan on patents involving or relating to the drug product Restasis. And there's a series of these, I think 6 IPRs. I'll acknowledge that our firm has some involvement in this dispute, so I'll try to just stick to some facts. But Allergan, on its own website, acknowledged that they had entered into an agreement with the St. Regis Mohawk tribe and paid the St. Regis Mohawk tribe $13.75 million to take an assignment of Allergan's patents, and as well as receive $15 million a year on royalties going forward. And then, of course, the tribe and Allergan argued that the tribe enjoyed immunity as an Indian nation. Allergan also put out a statement saying that this agreement had no impact on the pending litigation that was going on. They had just wrapped up trial in Texas on these patents when this assignment was made. More recently, I've seen reports that the judge in that trial in Texas is now requesting briefing about the transaction between Allergan and the tribe, and has questioned whether it's a sham or not, and I am going to issue zero opinion on that issue right there. And likewise, as I alluded to a minute ago, the Senate, as I understand it, has conducted some probes into this issue and is exploring whether there's a need for any legislative action. So stay tuned on that. That will, of course, the case will, of course, continue to attract attention from a variety of people. One issue, while we speak of sovereign immunity, one issue that I've not yet seen briefed in any cases at the PTab is the issue of foreign sovereign immunity, which is different from the other types of immunity that we just mentioned. And on to standing, as you probably know, there's no need to have standing under Article 3 of the Constitution to bring an IPR at the PTab. That's simply not a requirement to get in front of this administrative agency. But in a case that we handled on behalf of patent owner Immunogen, where we defended their patents successfully in an IPR and then the petitioner appealed, we brought this issue of standing to the forefront in terms of whether the petitioner needs Article 3 standing to appeal its decision as a losing petitioner. And we were able to convince the Federal Circuit that, yes, they do indeed need Article 3 standing to invoke the jurisdiction of the Federal Circuit, even though there was no similar standing requirement at the PTab. In this instance, the petitioner, as we showed, had not proven that it had suffered an injury in fact. This issue continues to be debated in a variety of contexts. I just, out of curiosity, tracked the cases. And one example of a case is the Momenta versus Bristol-Myers Squibb appeal from an IPR, where Momenta had filed an IPR and was unsuccessful and then appealed its decision to BMS. And in this instance, Momenta may one day potentially file an application for approval of a biosimilar drug, but they had not yet done so by the time they filed the appeal. And so BMS argued that Momenta's hypothetical future biosimilar drug application does not provide an injury in fact. And that case is ongoing. And even though we represent BMS, we don't work on that particular case. But the exact confines of what kind of injury must be shown and the details of it continue to be worked out in decisions up to the Fed Circuit. In the Phygenics case, the Fed Circuit said that this was the first time since their inception as a court 35 years ago, it's the first time they've had to address the issue of what is required for standing for an appeal from an administrative agency. And so I think we're going to continue to see that issue be debated.
Great. So last topic is appeals and remands, and I know we're closing in on the hour soon, so I'll go through this at a high level. Fortunately, most of these slides are fun graphs and images, so they're easy to go through. Slide 30, I mean, every time I look at this slide, I still get taken aback a little bit. I know the text is hard to read, but the kind of surging black line that crosses the red line up there in 2016, these are appeals to the Fed Circuit. The red line is appeals from district courts, where the surging black line is appeals from the PTab. So as you can see, in 2016, PTabs are now the biggest, PTab appeals are the biggest chunk of cases being heard by the Fed Circuit. You know, there was a delay. AIA was enacted in 2012. There was, of course, a delay for a few years until the appeals started ramping up in 2014. But I mean, wow, what amazing figures. And unfortunately for the court, they did not add any new judges in that time period. So it's a lot of additional work and a big chunk of their docket. So moving to slide 31, affirmances have been historically high. Back in early 2015, nearly all of the PTab appeals were getting affirmed. There were very few other types of disposals. You can see, fast forward to 2017, affirmances have dropped a bit down to 60–70%. Still not many reversals, but there are some remands kind of creeping up to almost about a third of the cases, and those are the more recent development. Slide 32, there was the Fed Circuit took a lot of flack in early 2015 for affirming many PTab decisions under Rule 36 summary affirmances, and a lot of disappointed parties, mostly patent owners, were saying, wow, we're getting a board decision from the PTab that leaves something to be desired in terms of specificity and explanation, and then we go on appeal to the Fed Circuit and you give us a Rule 36? Come on. So I think, either because of, managing workflow differently or other reasons, or maybe subject to, public pressure, the Fed Circuit has tamped down quite a bit on the use of Rule 36. Again, I don't know if I can blame them. They haven't added judges. There was a surge of new cases. They have to do something. So I think you're seeing decisions now that are relatively concise, although they're not Rule 36 decisions. And again, the overall rate of affirmances is dropping. 76% of all of the AIA appeals have been affirmed, but if you break it down, it was like 90% in 2015, 70% more recently, so there is a downward trend. I think one of the most interesting things is that kind of recent uptick in remands. If you look into the cases, what is the basis for remand? Based on some statistics that we compiled, 42% of those remands were due to the PTab's failure to sufficiently articulate its reasoning or support its judgment. You know, that is, anecdotally at least, that is kind of the gripe from a lot of parties, that the PTab, yes, they're going to disagree with the outcome, but they also disagree with the PTab not sufficiently explaining or supporting its decision with substantial evidence. And so in the early days, the complaint of disappointed parties, again, mostly patent owners, was we're not getting explanation from the PTab, and the Fed Circuit is rubber stamping it. They're not doing anything. Well, that seems to be changing a little bit now. There are, what's happening on remand, that is beyond the scope of this presentation. There aren't really, the board's, the statute and the board's rules don't really contemplate how you handle those.
But they have said they're going to come out with some guidance on that soon, standard operating procedures. And I've also heard them say that they want to issue a decision on the remand within 6 months of the mandate. So at least we have some guidance so far, and hopefully we'll get some more soon.
Yeah, so that's another issue that's evolving rapidly to watch out for. But with that, that concludes the presentation.
Yeah, thank you all for listening. We're happy to take questions if there are any questions. I think over the last 5 years, there have been many questions that have arisen when it comes to these proceedings, and it goes to show, these are IPRs and PGRs and CBM are their own special animal, and that digging into the case law and understanding the nuances of these proceedings is really important if you should find yourself embroiled in one. So thank you very much for your time.